Alright, welcome to the video lecture on Chapter 11, the criminal trial. So the first part of the trial involves the opening statement. This is not to argue, this is to describe and explain your evidence, your theory of the case, what you anticipate you will be able to present to the fact finder, judge, or jury. Prosecutor and defense have the option of doing it. Well, prosecutor does. Defense attorney is not required, and the defense does have the option to give their opening statement after the prosecutor rests their case. So, defense attorney has a little bit of the option to play strategy here. After the opening statements, remember again, not an argument. This is kind of more the preview of the trial. The presentation, the evidence starts. So here we're going to have the prosecutor start to present their case. They have this evidentiary burden of beyond a reasonable doubt. If the prosecutor does not present enough evidence to overcome the presumption of innocence, the defense can call for a judgment of acquittal, and if that is granted, that would mean the prosecutor didn't find their case and the trial would be over and the defendant would be released. That is not very common. Defendants are not required to present any evidence on their behalf. They can force a trial just to force the prosecutor to prove each and every element of the crime beyond a reasonable doubt. Witnesses that are that come to take the stand and present evidence are questioned by both the prosecutor and the defense. The side whose witness they are will ask direct examination questions. These are open-ended questions to gather evidence and experience. What's your job? What kind of training and experience you have? Where were you on this night? What did you observe? Just the chance to let the witness tell their story. Meanwhile, cross-examination are close-ended. Ideally, they will get a yes or no answer in response. And isn't it correct you don't wear glasses? Yes, things like that. So witnesses, defendants, we call witnesses because defendants' constitutional rights, they have that Sixth Amendment right in the Confrontation Clause to confront the witnesses against them. Again, this is not unlimited. It's okay for a child victim to testify behind a closed screen, or not behind to testify via closed-circuit TV. And we get those witnesses there by subpoenas that order the person to appear in court. Now, witnesses that have privilege are not required to testify or not allowed to testify about certain things. People who have privilege, the more common privileges that we see are those between a priest and their parishioner, between a husband and a wife, and a lawyer and their client. Each of these is a relationship that comes into contact with sensitive information that we want to encourage full sharing and full disclosure of the parties. So we do protect certain types of communications between these groups. Now, the lawyer-client, the exceptions would be if you have reason to believe your client's about to commit a crime that would involve serious bodily injury, then you can disclose, or death. Husbands and wives, the privilege, depending on where you live, is vested in either the defendant spouse or the witness spouse. The person who holds the privilege gets to make the decision about whether or not the other spouse can testify. Priests and parishioners, anything that occurs kind of within the confines of that relationship is privileged. So, now, these privileges are not absolute. They can be waived, and if they are waived, then the person is subject to just being a general witness. And then again, the defendant has their Fifth Amendment protection against self-incrimination, which they can also choose to waive. All right, so let's talk a little bit about types of evidence. So, real evidence is generally, there's often tangible evidence, things that you can touch or hold. Real evidence is something that will often link the defendant directly to that crime or the place. It is things like DNA evidence, fingerprints, the clothing worn on that day and time. While testimonial evidence, which is the more common type of evidence, is the statements of sworn witnesses. So when they take the stand, their direct examination, their cross examination, it might be a deposition, all of that is testimonial evidence. We also consider direct evidence. Direct evidence proves or disproves a fact. So a receipt for fireworks would establish that on the day, and it's direct evidence that on this day and time the defendant purchased fireworks. Indirect evidence is usually called circumstantial evidence. I think that's the more common term for it, and that means that we're going to have to interpret the evidence to come to a logical finding. So thinking about that firework receipt, that's direct evidence on that day and time the defendant bought fireworks. But it might also be circumstantial evidence, but it's only circumstantial evidence that those were the fireworks the defendant used the day and time of the crime. So the prosecutor's going to have to do a little more to get there with indirect evidence. Evidence is governed by the rules of evidence. The rules tell us that in order to introduce evidence to trial, the evidence needs to be relevant. Relevant is defined as any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. So we're kind of, any tendency means that this is broad. This is a broader rule. And then beyond that, witnesses need to be competent to testify. They need to be able to understand the difference between truth and a lie. They need to be able to communicate clearly, things like that. So when evidence is in the courtroom, if an attorney wants to object, they raise the objection, Your Honor, hearsay, and then the judge will decide the outcome of whether the question can be answered, whether the evidence is going to come in or not. Some common objections are about that the evidence is irrelevant, that the witness has not, that competence has not been demonstrated, or that the evidence it contains hearsay. So then the judge will decide based on the rules and the type of evidence whether or not it's admissible. There are a couple types of evidence that are restricted. So under the rape shield laws, the victim's prior sexual history is limited. Before it used to be fair game, and now we have it has become limited because it is irrelevant to this particular sexual assault. Okay. The times when it comes in is when the defendant and the victim had a prior sexual relationship, or it's needed to rebut something the prosecutor says. So that's a little bit about evidence. Again, evidence is pretty complex. We have an entire class just on evidence, so this is a very short, condensed overview. But after all of the evidence comes in, all the testimony, all the real evidence, closing arguments occur. And so closing arguments, what you do is you summarize the case with the goal to sway the jury. So this is the time where you can make an argument, where you can try to convince people that your side is correct. Now you cannot really comment on the evidence, but you can talk about, we demonstrated this element beyond reasonable doubt because of blank, or the prosecutor did not meet their duty because of blank. Prosecutor goes first, and then the defense. Prosecutors will frequently rebut. or reserve some of their time for rebuttal. Now, after the evidence comes in, after the case ends, the judge gives instructions to the jury. So the judge talks to the jury about presumption of innocence, proof beyond a reasonable doubt. They define the elements of the crimes, and they explain the defenses that are used. Some of the research on juries indicate that jurors often struggle to understand the content of jury instructions. They're very dense. So the type of language that's in them matters, and there has been a shift to provide more plain, non-technical jury instructions to just help efficiency and to help jurors actually understand kind of the parameters of their job. So jurors then deliberate. Sometimes they deliberate very quickly. Sometimes it takes a long time. Your book uses the example of the trial of Dale Hosner. He was charged with 87 different crimes, including 6 murders, and the jury there deliberated for 2 weeks. It was a very complex case with lots of charges, and they had to vote on every single charge. So the primary goal during deliberations is the defendant guilty or not guilty. It's assumed that jurors can assess witness credibility, determine what the credibility is, and ignore their own biases. And they are essentially interpreting and applying those instructions they get, which consist of the law of the case. However, the law can be kind of ambiguous, so we see that jurors can struggle with that. And we know that if there's not enough evidence, jurors engage in deliberation hypothesis, and we know that jurors frequently report considering irrelevant factors as very important in their decision. Okay. When we're talking about problems with trials, is we do know that DNA exonerations occur. We have the Innocence Project and other things. The common reasons for those wrongful convictions are that the witness misidentified the person. People are not very good at adequately identifying someone of a different race than them. We're especially likely to misidentify people who are of different race or ethnicity. So that is something that's going on. Now, when the jury comes back in, they speak as one, so the idea is that they should all agree. But remember, if we think back to the last section, we do know that the Supreme Court is currently deciding whether or not unanimous verdicts are required. Juries can nullify. Usually we end in conviction unless there's reasonable doubt. So nullification is only those times where the jury acquits despite evidence. This is usually done to be merciful because the jury views the law as unfair, the prosecutor as unfair. Now, hung juries are when the jury cannot come to an agreement, when there is this unclear outcome. So this is sometimes called a deadlocked jury too. This is common when jurors feel conflicted about the evidence is unclear, or the case is pretty complex. Now, for hung juries, prosecutor has the option to try the case again because jeopardy does not attach until a final verdict is reached. Now, the foreperson gives the verdict to the bailiff, then the verdict is read by the judge. The jury's decision is final and the judge cannot overrule it. If the verdict is not guilty, the defendant's released. If it is guilty, the defendant has the right to an appeal. And the direct attorney can ask for an acquittal from the judge at this point. So we covered a lot of topics. Some of them are newer terms. Some of them were more review. Please reach out and let me know if you have any questions or thoughts about any of the material. I look forward to hearing from you.